All right, everyone going to be ready for the 3:30?
Yep.
I'm ready.
All set.
Excellent. All right, good afternoon, everyone. It's 3:30, so let's go ahead and call number 11, which on my calendar, which is in the matter of 28 Partners LLC versus DVT 423K LLC and Kayop Alexander Kim. This case number is CV2026-010555. Can I get appearances, please? Be with counsel for the plaintiff.
Yes, Your Honor. Keisha Hodge on behalf of the plaintiff, 28 Partners. I'm with the firm of Ball, Stanton & McLaren.
Good afternoon, counsel. And to whom else do we have joining us here today?
With us, we have the plaintiff's representative, Jeffrey Ramsey.
Mr. Ramsey, can you go ahead and just introduce yourself, please?
Jeff Ramsey with 28 Partners LLC.
Good afternoon to you, sir. This matter was set for 3:30. Doesn't appear that anyone else is joining us. Everyone else is either a recorder or part of my court staff. There's no one waiting in my virtual courtroom or a virtual lobby waiting to be admitted into the virtual courtroom, so it doesn't appear that any defendant or defendant's attorney are timely appearing. So, Ms. Hodge, this is the time set for damages and default hearing. Are you ready to proceed?
Yes, I am, Your Honor.
Let's go ahead and take evidence first. So I'm assuming, I don't want to make too many assumptions, but based upon that previous motion to continue, I believe Mr. Ramsey is going to be your witness today.
That is correct.
All right, Mr. Ramsey, can you go ahead and raise your right hand because my clerk's going to swear you in?
You do solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, thank you, sir. You can go put your arm down now. All right, Ms. Hodge, let's go. Yeah, let's take evidence, and then I'll hear argument about whether why you believe the defendants are in default and why you're entitled to the relief you're requesting. But let's go ahead and be respectful for Mr. Ramsey's time. So you may begin your question when you're ready.
Thank you, Your Honor. The nature of the complaint has been by default has already been conceded regarding the nature of the lease of that sort. Unless you would prefer, I can do a quick background testimony if that's necessary, or just focus on damage. What is your? I want to make sure I'm mindful of the court's time.
Well, thank you for being considerate to me as well. I have prepared for today's hearing, so I have reviewed everything, including the complaint. So
Okay.
with that, I'll let you tailor your own evidence report presentation as you see fit, counsel.
Okay, thank you. I will go through it all then. Can you just state your name and occupation for the record, Mr. Ramsey?
Jeffrey Ramsey. I invest in retail real estate.
Okay, and what's your relationship to the plaintiff 28 Partners?
I am the president of Ramsey Real Estate Group AZ Inc., which is an Arizona corporation, and the corporation serves as the manager of 28 Partners LLC.
And how long have you been associated with 28 Partners?
Since its formation in 2017.
Can you tell the court your responsibilities with 28 Partners?
I implement, oversee, and handle all leasing, management, and accounting for the property, and oversee any vendors that are retained that we use on a third-party basis.
Okay. Are you familiar with the lease that is the subject of this lawsuit?
I am.
Can you tell us how you're familiar with it?
That is a form lease that 28 Partners LLC uses to lease space at this asset, and I inserted the previously negotiated terms with the tenant and guarantor into that document prior to presenting to them for signature.
Okay. And are you also familiar with the payment history, tenant files, and the amounts owed in this matter?
Yes.
Are the tenant records that we will discuss kept in the ordinary course of business for 28 partners?
Yes.
And is it the regular practice of 28 partners to maintain these tenant records?
Yes.
Your Honor, prior to our hearing, we shared the exhibits with the witness, so I'm going to just ask him about the same exhibits that has been presented to the court. The first one you have in front of you is exhibit number 1. Do you recognize that, Mr. Ramsey?
Yes.
Can you tell us what it is?
That is the lease between the tenant, the guarantor, and the landlord, 28 Partners LLC. The tenant being DVT423K LLC, and the guarantor is Dr. Kim.
Okay. And to the best of your knowledge, this is a true and correct copy of the lease, correct?
Yes.
Your Honor, I move to admit exhibit number 1.
There being no objection, exhibit 1 is in evidence, is admitted.
Thank you. Can you tell us when this lease was executed?
This lease was executed on June 20th of 2025.
And you identified the property being leased as 28 South Dobson Road, Suite 105, Mesa, Arizona, correct?
Yes.
What is the lease term on this for this document?
The lease term was for 3 years.
And when did the rent obligations commence under this lease agreement?
They commenced on June, excuse me, I apologize to the court, September 8th of 2025.
Okay. Before you have exhibit number 2, can you tell us what exhibit, do you recognize exhibit number 2?
Exhibit, I do.
Can you tell us what it is?
That was the commencement agreement establishing the rental commencement date entered into between 28 Partners LLC as landlord and DVT 423K LLC as tenant.
Okay. And to the best of your knowledge, is exhibit 2 a true and correct copy of the rent commencement agreement in this matter?
Yes.
I also move, Your Honor, for them to admit exhibit number 2.
Exhibit 2 is admitted.
Thank you. Under the lease, can you briefly explain the obligation the tenant had, what the amounts they were required to pay?
The lease commenced with a base rent amount of $4,599 a month, and then there was additional payment for a common area, a charge of $1,406.27 per square foot per month, which was a reimbursement for real estate taxes, insurance, and maintenance of the property. And in addition, as the property is located in Arizona, there was a TPT paid on both those funds, which are then remitted to the state for tax.
Okay. And let me back up real quick. To the best of your knowledge, did 28 Partners perform their obligations under the lease identified as exhibit 1?
Yes.
Okay. Was the payment of the minimum rent due on the first day of each month?
Yes.
Was tenant's pro rata share of the common area expense, commonly known as a CAM charge, also due on the first day of the month?
Yes.
Did the lease provide for a graduated minimum rent with annual increases? So in other words, year 1 was different than year 2 and year 3?
Correct. The base rent increased in year 2 to $4,829 per month, and in year 3 to $5,074 per month.
Okay. And the monthly CAM estimate as of January 1st, 2026, do you recall what that amount was?
It was $1,406.27.
Okay. And the tenant is also responsible for the applicable taxes. You mentioned the transaction privilege tax. Under this, if we added the city of Mesa and Maricopa County, it was, do you know what that amount is?
At the January 1 of 26, the base rent and CAM, when that calculated to the TPT percentages for Mesa, was $120.11.
Okay. Did the lease provide remedies if the payment was not timely received?
I should amend my previous answer to say that because there's TBTs calculated both at a city and a county level in a Mesa. So in addition to the Mesa $120.11, there was a Maricopa County TBT of $30.03.
Okay. And that works out to be, if my math is correct, 2% privilege tax for the city of Mesa and 0.5% privilege tax for the Maricopa County. Does that sound correct?
I believe that's accurate for at that point in time for Mesa and Maricopa, yes.
Thank you. Did the lease provide remedies if the payment was not timely submitted?
Yes.
Did the lease provide specifically for a late charge?
Yes.
Do you recall what the late charge is that is provided in the lease?
The lease provides for a 6% late fee if it's not paid by the first.
And it's 6% per month of the amount
Yes.
due? Thank you. In addition to the late charge, did the lease provide for pre and post judgment interest?
It did.
Do you remember the interest rate for the pre and post judgment interest?
That would be 2.5% over the, I believe it's the Bank of America posted prime rate at the time.
And the lease also include a provision for attorney's fees, those incurred by the landlord by reason of the tenant's default, failure to pay rent, and or any other charges when due?
Yes.
Okay. Also, before you have exhibit number 3, can you do you recognize that exhibit?
I do.
Can you tell me what it is?
That is the guarantor, a guarantee of the lease that was entered into by Dr. Kim in favor of 28 Partners LLC with respect to the lease for the premises when the premises was leased to DVT 423K LLC by 28 Partners LLC.
And to the best of your knowledge, is that a true and correct copy of the guarantee of lease executed by Mr. Kim?
Yes.
Your Honor, I'll move again to admit exhibit number 3.
Exhibit 3 is admitted.
Thank you. Mr. Ramsey, can you tell the court why the guarantee was required?
It was required to ensure that throughout the 3-year term of the lease, all of the tenant's obligations would be upheld, as the tenant itself did not necessarily have any assets that would be good and necessary to provide for payment of the lease term.
Okay. And it was signed by Keop Alexander Kim, correct?
Yes.
Okay. And what is your understanding of what was meant by the guarantee being unconditional?
Well, in the event that the tenant failed to perform a financial or other obligation as spelled out in the lease for the premises, that the guarantor would make good on those obligations of the tenant.
Okay. Did the tenant actually default in the situation?
Yes.
Did Mr. Kim satisfy the tenant's obligation after default?
No.
Did the tenant make all required rent payments?
No.
When did the tenant first default?
The initial default, I believe, was in December or January. I'd have to look at my notes specifically, but maybe January of 2026.
Okay. And the tenant continues to be in default?
That's correct.
Is this considered a material breach of the lease obligation?
Yes.
Okay. You have before you also exhibit number 4. Can you tell us, do you recognize that document?
Yes, I do.
Can you tell me what it is?
That was a demand letter sent to the tenant and the guarantor dated January 14th of 2026, demanding payment under the terms and conditions of the lease.
Your Honor, I move for the admission of exhibit number 4.
Exhibit 4 is admitted.
Thank you. To the best of your knowledge, this notice of default was sent to the defendants correctly? Correct?
Yes.
It was sent to both defendants.
It was yes, to the tenant and the guarantor, both defendants, correct.
Thank you. And it shows the documentation also included proof of delivery, correct?
Correct.
And I know this might seem duplicative, but did either defendant cure the default after receiving notice?
No.
After the default, what actions did 28 Partners take?
After the expiration period of the notice of default and concurrent with our obligations of timing under Arizona law, we eventually retook possession while maintaining our contractual remedies.
Okay. And when did do you remember when possession was retaken?
Approximately January 23rd of 2026.
Thank you. Did the defendant's breach cause damages to 28 Partners?
Yes.
Have you calculated the rent amount due through March 9, 2026 when the complaint was filed?
Yes, we have.
Can you look at exhibit numbers 5? Can you tell me what it is?
That is a calculation made with respect to the rent that was due from January 1 of 2026 through March 9 of 2026.
And to the best of your knowledge, that is an accurate calculation?
Yes.
Your Honor, sorry. What is the total amount of past rent due through March 9, 2026?
$19,574.29.
Thank you. Your Honor, I move to admit exhibit number 5.
Exhibit 5 is admitted.
Thank you. Turn to exhibit number 6, and can you tell us what that is?
That is a calculation of the remaining rent from March 9th of 2026 through the conclusion of the term.
And what do you calculate to be the total amount of remaining rents as of March 9, 2026?
$187,178.15.
Your Honor, I move to admit exhibit number 6.
Exhibit 6 is admitted.
Thank you. Mr. Ramsey, has 28 Partners received any amounts from any source offsetting the past due or remaining rents?
No.
So exhibit 5 and 6 represent the total of rent amount due.
Yes.
Do the amounts also include it includes the minimum rent, the CAM charges, taxes, and late fees as appropriate, correct?
Yes.
You acknowledge that the remaining rent is subject to a reduction if a replacement rent or a tenant is received, correct?
Yes.
28 Partners has made attempts to relet the premises after taking possession, correct?
Yes.
Before we talk about the steps taken to relet the premises, let's talk a little bit about the condition of the premises when 28 Partners took back possession. Specifically, there was the storefront doors. Can you tell me what condition they were in?
At some point in November or December, when the tenant was operating from the premises, they had experienced a smash and grab attempt burglary. And in doing so, the glass of the 2 entry doors leading into the premises was destroyed. They replaced that with a plexiglass type of product, which was neither compliant with the lease nor with building standards.
Okay. So did 28 Partners incur expenses to replace that plexiglass?
Yes.
And I'm going to ask you to look at exhibit number 7. Can you tell me what that is?
That is the initial quote, which turned into an invoice that we paid in the amount of $1,005.47 with Roadrunner Glass, who's handled the window door replacement, the glass in the doors replacement, due to the condition of the plexiglass that we had returned to us when the premises came back to us.
Thank you. Your Honor, I move to admit exhibit number 7.
Exhibit 7 is admitted.
Thank you. Tell us, Mr. Ramsey, tell the court what condition did 28 Partners find the premises when you retook possession? Was cleanup necessary?
Cleanup was necessary. There was general debris strewn about the premises, packing equipment and packing tape and material like that, as well as some spoiled food and a variety of other things that were left in the premises when we regained possession.
Okay. Can you look at exhibit 8 and tell us what that is?
That is an invoice from Sonoran Property Maintenance, which is one of our vendors who cleaned the space when the tenant moved out.
Okay. Can you tell me tell the court what the cost was that was incurred?
$164.96.
Thank you. Your Honor, I move to admit exhibit number 8.
Exhibit 8 is admitted.
Thank you. I may have asked this already, so I apologize, Mr. Ramsey. Did the lease provide for recovery of attorney's fees?
Yes.
Does a guarantee also provide for the recovery of attorney's fees?
Yes.
Have attorney's fees been incurred in enforcing these agreements?
Yes.
Has that been provided as part of our affidavit of attorney's fees?
Yes.
Okay. Let's talk a little bit about the steps that you took to mitigate the damages after 28 Partners took repossession of the premises. Can you tell the court what steps were taken to mitigate damages?
Well, the first thing we do anytime a space comes back to us is have all doors, in this case there's a front door and a rear door, rekeyed so there's no loose keys floating around, but provide access to any parties that are not entitled to be into the space. We directed our vendor, Sonoran Property Maintenance, to clean the space. We then placed a leasing sign on the window of the premises, as well as entered the applicable available space for lease into CoStar, which serves as a, for lack of a better term, a Bloomberg terminal for real estate professionals to subscribe to that service. And then further through CoStar, we contract with their affiliate LoopNet, which allows anybody in the general public to see the leasing information that we've placed on the market about the available space as it's now available for lease.
Thank you. Exhibit number 9, can you look at that and tell us what that is, please?
That is a picture of the for lease sign placed on the window of the premises.
Okay. Do you have an idea of when those photos were taken?
Probably early February,
Okay.
once the space has been cleaned.
Based on the notes that are on there, one was taken on February 2nd, 2026, and the other on July 29, 2026. Do you have reason to disagree with that?
No, because I would have taken the pictures and noted the dates.
Okay. Just wanted to make sure. Your Honor,
I appreciate that.
I move to admit exhibit number 9.
Exhibit 9 is admitted.
To the best of your knowledge, Mr. Ramsey, are the for lease signs still posted at the premises?
Yes.
Okay. Exhibits number 10 and 11, can you look at them and tell us what they are?
Exhibit number 10 is if a party went on to the LoopNet website or the LoopNet app on their phone or their computer device, what the for lease listing for this particular property, which includes the premises that are subject to this lawsuit, and what parties viewing it would see, and how they could contact me to discuss it, as well as some basic information regarding the size of the premises and our quote rates and several other facts about the premises. That is Exhibit 10. Exhibit 11 is what real estate professionals who've subscribed to the CoStar system itself, what they would see with respect, again, the Bloomberg style terminal for real estate people, and lack of a better term, what they would see if they were to log on, view the property record itself, or conduct a search of available space for lease in the Mesa market or whatever criteria they may put in. This is the information that will come up, again, showing the space available for lease, our quote rate, our CAM charges, contact information, and then the availability to download a PDF with the same information to distribute to their clients and whatnot.
Okay. Your Honor, I move to admit exhibits 10 and 11, please.
Exhibits 10 and 11 are both admitted.
Thank you. And your testimony, Mr. Ramsey, was that you, let me not put words into your mouth. When did you create, do you recall when the LoopNet and or the CoStar listings were created?
Initially, right as the space was again in our possession, we attempt to get them same day right out there. We don't ever want to miss anybody that might be coming across looking for space. So I think the LoopNet one says a little bit differently. They've changed. I apologize to all parties. They've changed the layout of these over the years since we've started using them, and they can't find everything exact place. But within days of us regaining possession, it was initially entered into CoStar and into LoopNet.
Okay. And the 28 partners continue to parcel for lease?
I'm sorry, we lost people there for a quick second.
Yeah,
I
Counsel,
know,
can you
it's been
re-ask
good.
that question? Yeah, I'm not sure what
Yeah.
happened. Can you just re-ask that question, Counsel?
No worries. Thank you. The question was, does 28 partners continue to market the premises for lease?
We do. We continue to make sure that all the information is up to date on a very regular basis online, so parties can view it.
Has 28 partners received any letter of intent or offer on the premises?
Since we began marketing the premises, we've received several letter of intents, and we we've countered all those very timely, and we have proceeded to negotiate where possible with the interested parties. None of them to date have come to fruition.
Okay. But as part of that process, if the prospective tenant needed to see access to the premises, you made the premises available?
Yeah, absolutely. We have a digital lockbox on site, and we can provide 24/7, 365 access to any party that wants to see it at any point in time if we don't happen to be there. They can literally stand in front of the space, be on the phone with me. I can send them a digital code. They can access the lockbox, be in and out of the space instantaneously.
Okay. Based on, it goes without saying, but I'm going to ask it clearly. A replacement tenant has not yet been secured, correct?
Not yet.
Okay. Have reletting expenses been incurred to date?
Yes.
What are the reletting expenses?
I'm sorry, not reletting specific to a new transaction. No,
Okay.
we've incurred costs that are not subject to this action with respect to paying for it to be in CoStar and LoopNet and things like that. So
Okay.
reletting in and of itself, no.
Okay. Based on your experience, if you had to estimate what is a projected reletting expenses, do you feel qualified to provide that?
Yes.
Can you tell me how much you think your calculation and how you came to be?
We feel at a very minimum, if we're lucky, we'll only be putting $10 a foot in TI into it. I think I won't take the court's time up, but it's very low at this point in time now, as we've learned recently in other transactions. And then we'll incur brokerage expenses as well, equal to approximately 6% of the base rental amount.
And if you had, sorry, go
I said
ahead.
we'll incur downtime for negotiating a transaction and providing an additional time for a tenant to build the space out, obtain the permits and things like that.
And if you had to estimate the dollar amount of that, what would you think? What do you anticipate that to be?
Well, we anticipate at a minimum we'll be incurring $15,000+ in tenant improvement money and leasing commissions. Will be judged based upon the length of the transaction, but that's typically easily a $25,000 cost.
Okay, thank you. So just to summarize for the court, the damages testified thus far include past due rent of $19,574.29, remaining rent of $187,178.15, the glass replacement of $1,005.47, the cleanup cost of $164.96, and the anticipated reletting expenses of $25,000 per the complaint was $566. That brings it to a total of $233,488.87. You also testified that there was pre-judgment and post-judgment interest at prime, which is 6.75 plus 2.5%, which nets to 9.25. Attorney's fees that are capped per the complaint at $3,500, and the taxable costs per our statement of costs. Are there any other additional damages that 28 Partners seeks in this action?
No.
Thank you. Thank you, Mr. Ramsey. I'm sorry, Your Honor, that concludes my question of the witness.
All right, thank you. I have no questions for this witness, so this witness may step down.
Thank you.
I use air quotes there for the purposes of this transcript because, well, it's virtual court, so.
Yeah.
Counsel, you may call your next witness if you have one.
No, I do not have any other witnesses, Your Honor.
All right, well, so are we ready for argument then?
Yes.
All right, so why don't we go ahead and why don't you argue whether the defendants have been properly served, whether they're in default, and what you're requesting and why, and whether you're entitled to your request.
Yes, Your Honor. Yes, the defendants are both in default. They have been served with the complaint. We received court permission. The defendant DK, sorry, I spelled it wrong. The DKT 437, I think. Sorry, let's say it right. DVT 423K LLC were served via their stat agent. They have decided not to appear despite proper service. We also received court permission to serve Mr. Kim via notice, public posting and a notice and mail to his home, his residence. And he has also not appeared. The time for them to respond has passed. They have both defaulted and admitted the allegation of the complaint. We have, as a courtesy and per the court order as to the last, all of the records to the
I'm sorry, counsel, I'm going to interrupt again. We had that little hiccup like we had during Mr. Ramsey's testimony. If you just want to repeat what you had, I'm not sure what is causing that, but it seems like it's not just affecting me. It seems like it's affecting some other individuals as well.
Okay. Yeah, I apologize. I'm not sure what happened. I'm not sure what you heard, but so I will start off. We did serve DVT 223K via their stat agent. We did effectuate service of our complaint in accordance to the rule. We also sought court approval for alternative service to serve Dr. Kim via post and mail. After several attempts of him avoiding service, we saw this was a pattern that he had done in other cases, and the court did grant us approval to serve him through alternative service, which we did submit that proof of service to the court. In both cases, the default proceedings, the notice of default, the time passed and they still have not responded. We filed a motion for entry of default. We filed a motion for default judgment, all of which have been served on the defendants and they have failed to respond. We believe that under the rules, this is an admission of the allegations contained in the complaint, and we ask that the court move forward with that. In respect to the damages, we believe that they are in line with what the lease provides. As you've heard from Mr. Ramsey, they have made diligent efforts to lease the premises. Unfortunately, the market is simply one where this site is not, the market itself is not necessarily one that is attracting tenants, and we are still doing the best efforts to recoup but we believe that the lease damages, it did it again. I saw it that time. I was going to say, so we believe that the damage sought are consistent with what the lease provides, both the lease and the guarantee provides in the situation, and we are asking for the full amount of the damages that has been articulated by Mr. Ramsey.
Okay. Well, I have the complaint up, and I heard testimony that door replacement for I guess the theft damage of $1,005.47, and I've got your complaint up on page 9. Your prayer for relief for theft damages totaling $1,000.
So that's the glass. The glass is the $1,000. It's like 1,050.
Yeah. Okay.
Yeah.
So are you asking for theft damages totaling $1,000 then?
Yes, correct.
Okay. And then the cleanup expenses, in your complaint, you've got it as $500, and also in my proposed form of default judgment, I have it at $500, but the evidence I heard is $164.96.
That is correct, Your Honor. Based on the evidence, we were able to, the documentation, we did, it does go down.
All right. Reletting expenses of $25,000, not $25,566.
That is correct, Your Honor.
And you're praying for attorney's fees in the amount of $3,500 and statement of costs of $1,604.16.
That is correct, Your Honor.
Okay. Well, counsel, I do find the defendants to be in default. I reviewed this matter, and I agree with you that they're both in default. There looks like the LLC entity, I'm not going to try and say that name, was served on a stat agent back on March 18th. Dr. Kim was served via alt service back on May 4th. There was an application for entry default for the LLC on May 4th, and Dr. Kim's application for entry default May 27. And again, there's no answer or other defensive filing filed within the allotted time. So the defendants are in default. Based upon the evidence before me, and I do agree that the well-pled facts of the complaint are deemed judicially admitted based upon said default. I have made the modified, I have reviewed the default judgment. I've gone through the modifications with you, counsel, based upon the evidentiary presentation. I've made the appropriate modifications, and I will enter the default judgment here of record here today.
Thank you so much, Your Honor.
So I'm granting your motion for the default judgment and enter the default judgment. So, counsel, is there anything else we need to talk about on this matter?
No, that is it, Your Honor. Thank you so much.
You're very welcome. If there's nothing else, this matter is adjourned. Have a good rest of your day, okay?
Thank you, you too.
Bye-bye.
Bye.
Well, that's it for today. So thank you, everyone. Have a good